Good afternoon, please be seated. Good afternoon and welcome. I'm Judge Tony Diesel. We're here today in Spokane County Superior Court, Department 6. Can the parties hear me over in the jail courtroom?
Yes, Your Honor.
All right.
Yes, Your Honor.
We do have a working Zoom hearing and all participants are able to hear and see each other. With that, Mr. McCullum, if you'd be kind enough to start us off with a caption.
Yes, Your Honor. This is the matter of the State of Washington versus Aaron Farinacci, cause number 26-1-102-3532. State of Washington present, represented by myself, President McCullum. Mr. Farinacci is present in custody, represented by his attorney, Colin Charbonneau.
All right, thank you. And the court is situated in a live courtroom. We have members of the public and media present. I want to take a moment, Mr. Farinacci, and go over some important rights that belong to you. The state has filed an information, which is a charging document, alleging you committed first-degree arson. You have important rights being accused of a serious crime. I want to make sure you understand and are informed of those rights. Anyone charged with a crime has a right to a speedy and public trial by an impartial judge or jury. You have a right to a jury trial here in the county where you're alleged to have committed the offense. In other words, you have that right to a jury trial. You have a right to be represented by an attorney throughout the entire court process. If you can't afford your own attorney, one would be appointed at public expense and no cost to you. At trial, you have a right to attend and be present for your trial. You have a right to testify at your trial if you so choose. You also have the right to remain silent both before and during trial. You have a right to hear and question any witnesses that the state will call to testify against you at trial. That's called the right of confrontation. And you also have the right to call your own witnesses at trial. If you need the courts to order and make your witnesses appear at your trial, that would be done at no cost or expense to you. Your rights also include being presumed innocent. That presumption of innocence remains with you throughout the entire court process unless you enter a guilty plea at any time in that process, or unless the state is able to prove at trial every element of the offenses charged against you beyond a reasonable doubt standard. Finally, if you were hypothetically found guilty at a trial, you would then also have a right to appeal both the conviction and the sentencing to ensure there were no legal errors in the process. I'll further advise you, in addition to your rights, that all court hearings, including today's first appearance, are recorded and made on the record, so anything you ever say in court can be used against you by the prosecution. With that, Mr. Farinacci, did you hear and understand the rights that I went over?
Yes, Your Honor.
Could you please state for the record your true name and date of birth?
Aaron Forrest Farinacci, March 10, 1989.
All right, with that, we're here today for a first appearance to determine release conditions. I've reviewed the PC affidavit. I've noted a previous judge already found probable cause. So I'll hear the party's position with respect to release detention. I'll hear first from the prosecution. Thank you.
And Your Honor, as the court indicated, probable cause was previously found. I am asking the court to impose release conditions to include a bond amount of no less than $1 million, asking the court be maintained in custody in the Spokane County Jail, asking that the court impose conditions of appearing at all court dates, staying in contact with his attorney, remaining within Spokane County, committing no further law violations, obey any and all court orders currently in effect, not to approach or communicate with any witness or victim listed in the probable cause affidavit, likewise not to frequent any location or known location listed in the PC affidavit, as well as crime-specific prohibitions of no use, possession of any lighters, matches, torch, or other fire-starting devices in the event a bond was in fact posted. It is the state's position that, given the nature of the charges, given the nature of this offense, that the defendant poses a danger to the community, and the CRR 3.2 presumptions are overcome. So we are asking the court to impose these conditions.
All right, thank you. I'll hear from Mr. Charbonneau.
Judge, Mr. Farinacci is reserving argument with respect to probable cause, bond, and release conditions today.
All right, thank you. With that reservation, I'll note the defense's reservation with respect to the release conditions. The court will adopt the $1 million bond that's already in place and adopt all the proposed release conditions as suggested by the prosecution. I'm going to set an arraignment for August 6th at 3 p.m. for Mr. Farinacci. And I believe that concludes most of our matters for today, unless there's anything further from either party.
And Your Honor, I'm going to finalize this order. My understanding is that I'll need to deliver a hard copy to Your Honor, so I'll do that directly after the hearing, once the parties have signed off on that.
All right, thank you. And Mr. Charbonnet, you're welcome to note your reservation.
Will do, Judge. Thank you.
All right, I appreciate everyone's work, and that concludes our hearing today.
Thank you, Your Honor.
We're in recess.